We are now ready for the afternoon case of State versus Canady, and we have Mr. Sloven and Mr. Bender. Mr. Sloven, you may begin now. You get to.
And may it please the court, counsel. Good afternoon. It's a privilege to be here. So I want to start with something I think is not controversial. The Court of Appeals found there was overwhelming evidence to support the two additional charges, the willful injury and the assault. They are supported by overwhelming evidence, not by principal liability, not by aiding and abetting. A finding that overwhelming evidence supports those charges should have led to a finding of harmless error. So at the very least, those two convictions should be affirmed, even if retrial is necessary on voluntary manslaughter. Now, I also think that even if you think the admission of these two bits of evidence was in error, I still think that's harmless as to the voluntary manslaughter conviction as well. The relevant events are captured on video and described by an eyewitness. The Snapchat post is, in particular, relevant to prove that Evans made statements that he had a gun, put on Snapchat that a statement that we may look good, but we're also carrying guns. Goodman explained what those words mean. The thing that proved was cumulative with other evidence showing that Canady knew that Evans had a gun. He tells the
Snapchat video photo, first of all, the defendant's not in it, correct? Am I correct that district court did not analyze it as co-conspirator?
It initially said that might apply. I believe that was in the motion in limine ruling, but then it deferred. Now, I think that on hearsay, it's clearly admitted for the effect on the listener, on anyone who scrolls through the Snapchat, just like Goodman did, and sees the gun and then has knowledge that Evans is saying. So it's not admitted for the truth of the matter asserted that he actually has a gun at that point. It's admitted for I think there are also other hearsay exceptions that could apply that we discussed in our brief, but the clearest route to understand this is that it's not particularly relevant whether Evans was carrying a gun on him at that moment, only that he was saying that they had gun.
Yeah, these evidentiary things are a morass, and we don't always see out of it. Let me try and see what I think is my path to understanding it. So in the Snapchat photo, you have Evans and that other kid, and Evans has got something in his waistband, and then they're talking about having, according to the interpretation, that they have guns, and
the photos and it before I drafted the application for further review.
Your point is that it's sort of a statement of intent. It's not really a statement. We actually have guns. Is that what you're saying?
It says we're bussin', but don't think it's sweet. And Goodman explains what that means is that it's kind of, look at the fit, look at the drip, right? But don't think that we don't have guns. And then there's the gun emoji that kind of dispels the uncertainty there as to what that means.
And that could be a gun, is that?
Item that could be a gun. It's kind of, the photo is not quite high enough resolution to say for sure, but the way that they're gesturing suggests, like they're showing the waistbands in that way. And I also think that the way that the post is written could also be stating that, like, look, you can't see the gun, but don't think we don't have it.
And then the judge initially said, well, no proof that Canady saw this photo that evening. And your response, but eventually, nonetheless, the Judge Tott let it in. And your response, and why you think that's correct is there's a lot of circumstantial evidence he would have been able to see it. Is that?
Things Goodman says in that offer of proof exchange just before the ruling is, Goodman says, look, I'm on Snapchat. I'm friends with both of these people, and I know that Snapchat users look at each other's posts. In fact, you have to. If you don't look at it within 24 hours, generally it disappears. The whole point of being on Snapchat is to see each other's posts. And so the analogy that we use in the application for further review is if Evans was standing on a hill and shouted, I have a gun, and there's evidence that Canady was seen somewhere in the vicinity of that hill, that statement is admissible not to prove the fact that Evans had a gun. It could also do that, but it's specifically admissible to prove that Canady had a way to know, Canady may have known, that that Evans had a gun. Why? Because he was in a position to hear that statement when it was made. And here, I mean, there's also evidence that that Snapchat was on Canady's phone that evening, that Goodman takes the snapshot of the location tracking where it reports Mr. Canady's location. So Canady had Snapchat and it was running on his phone that night.
Trying to work this out in my own head, and maybe I'm behind the rest of the members of my court. You don't really need to prove that Evans had a gun, because in the end, he had a gun. He killed Harrison. But what the state needed to prove was that Canady knew Evans had a gun.
Proof is more useful for the first-degree murder charge that the jury ended up rejecting, that it was a premeditated plan to go to the bar in order to kill Tezo, Mr. Harrison. Once they're there, Canady clearly knows that Evans has a gun. He tells the bartender, "We have guns." Goodman testifies that he instructs Evans to go get the gun. And
Question, just factually, did Goodman kind of walk that back in other testimony?
so her exact words were that Canady said, "Go and get that." But the way in which it was said, she understood it to be about guns, and she responded in kind. She said, "Now we're going to gunplay now. We're getting guns now." And like nobody said, "We're not talking about guns," right? It was clear from context to her that that's what it meant. And in the context of Canady is seeking the violent confrontation, saying, "Tezo, get out here," and then instructing Evans to go get that. It's clear from the context what he means. It's also clear from his statements to Anderson that that's one of the first things he mentions to her is that we've got guns and we're not afraid to use them, basically. So, and that is a good lead into establishing that, especially, so first for the Snapchat post, right? The thing that it's there to prove was at least, especially as to the aiding and abetting voluntary manslaughter charges, already convincingly and overwhelmingly established by other evidence. Multiple other sources saying that Canady knew that Evans had a gun and instructed him to get it so that it could be used. Now, for the rap video, I appreciate the ACLU's briefing. I think there are a lot of interesting cases out there. I do not agree with the idea that there are three factors that are required or mandatory before evidence of a rap lyrics or a rap video becomes admissible. I think that this analysis should be performed with the same tools that district courts already use for weighing probative value against prejudicial effect. And there's all kinds of facts, case by case, that may become relevant in that analysis. And there are some that it's appropriate to mention that may be, should be looked at in certain ways and may take on certain relevance. But there's no hard and fast rule that, for example, if the rap is composed before the alleged crime, that it becomes automatically inadmissible. The ACLU suggests that in order to be admissible, it has to be after. Well, the Bryant case from Indiana, the rap lyrics were admissible specifically for motive and intent because they foretold the death of the victim in the manner specified.
So and you can correct me if I'm wrong, the rap video was 5 days before the murder, right? And the plaintiff was arguing, and the state was arguing that the defendant's motive was the phone call, which happened the day before the murder.
I would say that, so the prosecution's theory here is that it's kind of a double, there's a background motive and then a precipitating motive.
About that was argued a lot at court, wasn't it? And yet that timing, it was impossible for the 5 day before to be the motive when the incident didn't happen until the day before, as far as the phone call.
Well, the precipitating motive, right? But if somebody
thought it was my review of the record that no other evidence of motive before the phone call.
And, that's kind of something that arises from, it's not all that common to get people explaining to you who they have beef with and why. So it's kind of a scarcity of evidence in that regard some ways. What I'm trying to and I think that the case looks different in hindsight.
Harris and Canady had kind of an on-again, off-again beef relation. They would fight, and then they would make up or at least come to terms, and then they would fight again.
Characterized by the defense as being that they are consistently friends. Now, if this evidence looks different in hindsight, especially with the fact that the district court didn't already know when it admitted the evidence, which is that the specific name is said in the video or in the the song, the recorded song that they're rapping over the top of. The name wasn't added as an ad lib by Mr. Canady. It was in the original song.
The thing that was recorded on the cell phone, just the 20 seconds that we have, is that right?
Believe so, or at least that's what was given to the court in the redacted version.
You know, I understand the state's argument is even if it's a song where the underlying song uses Tezo and refers to Tezo, of all the songs out there, these two individuals who were charged essentially with jointly committing this crime picked out a 20-second segment of the song that mentions Tezo.
Dovetail that in with, to critique the ACLU's point that it should be a requirement that the defendant authored the lyrics for them to be admissible. Selection matters too. If I choose to karaoke the song, I shot the sheriff, and then I proceed directly to the sheriff's house and kill them, right? It doesn't matter that it was originally authored by Bob Marley or Eric Clapton or whoever you think is better.
It's under 403. You have to agree with me that this video on the unfair prejudice scale is super high.
Well, I think that there are...
Also has to be super high.
So I think that there are things in the video that are indicative of like kids idolizing rappers for sure, that they're posturing. Now, the thing is that this is all something that can be brought out in an attack on the weight of the evidence to establish, to talk about like, well, why is this happening, right? And the defense, I think, does this pretty successfully by playing the actual video of the song, or not really the video, but a slideshow, and showing like this is the real person. In terms of probative value, we give so much deference to the district court in weighing probative versus potential for prejudice. And the district court specifically says, I would not admit this. It says so in the written ruling, but for the fact that the decedent's name is inserted here, the decedent's name is said here.
District court know that this was based on an actual song? I thought there was some argument about that.
I think that when you listen to it, it's clear that there's at least something external as the origin, but it's not clear whether the name Tez or Tezo is in the original song or if that was added by Canady replacing it or saying it over. I think that what the district court didn't know and couldn't get from the video was that that actual name is not something that the defendant added. And Mr. Cannady's counsel knew that and then saved that until after the video came in to make a, I think, very effective attack on the weight of the evidence. And the jury rejected the theory that there was a pre-existing, premeditated motive to kill. So I think one of the things this shows is that it is possible to have an effective attack on the weight of evidence like this that can overcome its potential prejudicial value. I also think that,
Turn to one other issue before time runs out. Can you address the merger issue, please?
So the merger issue is easier here because this is a vicarious liability theory for voluntary manslaughter and a principal liability theory for willful injury. That he's being charged and convicted of aiding and abetting somebody else's acts for the arguably greater offense, and then his own acts for the willful injury. It's also, I think, foreclosed by Soretti, which considered the issue of merger between these exact two crimes and found that they didn't merge, and then remanded for proceedings consistent with that.
On instruction 40, are you saying the intent to do bodily injury was the attempt to murder? It wasn't the punching and the kicking and the beating, and that's what makes... So I guess I'm not understanding your distinction between the principal liability and the aiding and abetting liability and why that matters here.
Yeah, my understanding was it was the punching and the kicking that was the predicate for the lesser offense, and as instructed.
Yeah, I thought we're both aiding and abetting. In other words, I thought the willful injury was aiding and abetting the shooting, and the voluntary manslaughter was aiding and abetting the shooting. And so it seems to me a pretty narrow path to travel to say that you can aid and abet a shooting without specifically intending to harm the victim.
So I think In the event that I'm misremembering, the
Jury instruction 40, see if this clarifies it for you. The state must prove all the following elements of willful injury causing bodily injury. That's what we're talking about, correct? On or about the first day of May 2021, the defendant aided and abetted Dwight Evans in shooting Martez Harrison. The defendant specifically intended to cause a bodily injury to Martez Harrison, and then on and on. So, isn't it the same, I guess, for voluntary manslaughter?
was wrapped around the axle on which axle. So in that case, what you would have is exactly the situation described by Soretti, where the non-mutuality of elements here precludes any merger because the voluntary manslaughter requires the killing and but doesn't have a particular intent requirement as to the causing the bodily injury.
The voluntary manslaughter also required aiding and abetting, which means he had to have known and ascended to the shooting in order to be guilty of voluntary manslaughter, right? That was part of the instructions. So how do you know and assent to a shooting without specifically intending that the person be injured?
So
I don't see a pathway that you could commit willful injury causing bodily injury without without committing I'm mixing it up, but you understand my question.
aid and assent and participate that's inherent to aiding and abetting is not a specific intent to produce a particular result. It's assenting and participating in a particular action that's a general intent act. So that's where the distinction arises. Thank you.
Mr. Bender.
May it please the court. Chief Justice, fellow justices, Mr. Sloven. Good afternoon. I am Bradley Bender. I'm here on behalf of Mr. Canady. I think it can be safe to sum up the state's argument as speculation and conjecture on all the arguments that they have presented here today. You know, if we look at the rap video here, they're speculating what occurred on April 26th on what his motive was on April 30th. There's nothing about the rap video that has any probative value or any relevancy, you know, with respect to that.
It's no relevance. I mean, first of all, I think Mr. Sloven raises a valid point. In other words, it could be that the rap video is relevant to show that Evans and Canady had some animosity toward Tezo, and then it was, you know, sort of the triggering event was when there was the phone call with Rockwood, on the 30th. But certainly, it would be helpful if I was in the state's position to show that 4 days before they were also talking about killing somebody named Tezo. That seems to me relevant. We can talk about whether it's prejudicial, but it seems relevant.
We're sparsing at the words of a video that he did not write. I think that's very important. Number one here is Canady did not write these lyrics. And that is if you listen to not only State Exhibit number 90, which is the 30-second video off the cell phone, but then also compare that to the defendant's exhibit that was emitted of the Netzel side on 63rd to 65th rap video, the whole 2 minutes and 57 seconds.
Your client got to argue to the jury, though.
But the missability of it, because what happened here is the state is making the inferential leap of saying that he is saying Tezo, but he's not saying Tezo. There's other names that are being mentioned in even that 20-second. He talks about Kells. That is the second name that was mentioned besides the word Tezo. Tezo is not Tezo. I mean, you know, that's the whole idea here.
Argument to make to the jury, and then they get to decide what they heard. You say ying, they say yang, and the jury gets to listen.
This is misleading the jury. The state is trying to find a way to show their intent and motive, and they're grasping at straws here. And I think that's the whole idea here, is that this video is very prejudicial to the jury because of the irrelevancy of it. Because it doesn't take...
Like Tezo to me, neighbor. I mean, but of all the rap songs out there, thousands of rap songs, he picks this one. Isn't that significant?
Well, we know that slide is a Chicago-based rap group. And we also know that Canady grew up in Chicago and that he lives out here in Sioux City. So that is not it's not abnormal that he would take his hometown rap group and listen to it and also record it. I mean, unfortunately, teenagers nowadays, they record things and they post things that they probably shouldn't have post. But I mean, it's not a illogical argument to.
He said it. Whatever his motives for saying it are really irrelevant. It was recorded on video. It's an admission by a party opponent. As long as it has some marginal relevance, it's admissible unless it's prejudicial. You can argue whether or not he adopted it, whether he meant it, whether teso means teso, but those are all jury arguments, not admissibility arguments.
One step here. The second step is the prejudicial aspect. I think under 5403, this clearly should not have came in, because we get into the idea of, when we talk about rap videos and the connotation that is made to the jury, and I think the research has clearly shown that prosecutors are using rap lyrics, rap videos to try to convict defendants. And there's no denying that. There's over 500 some cases since early 2000.
I can think of a lot of cases out there where a video like this would be very prejudicial. If the question was, were these two guys even involved in something? There was, you were talking about a circumstantial case. You don't even know if they were there. You don't know if they did it, and you're using the video to infer, as sort of character evidence. That would be one thing. But here, there's no doubt that Evans shot and killed Harrison, and that Canady was there beating up Harrison as Evans was shooting him. All of that is undisputed. The only issue, the only fighting issue that the state is really fighting over is, what were the two of them acting together? And in that sense, to prove sort of their collaboration, I have trouble seeing that it's that prejudicial, and I think it's somewhat relevant to have that 2 days before they're, in a car, I guess, recording a 20-second rap that mentions the decedent's name, or arguably mentions it.
Theory at trial, then fine. Then that argument may have some weight, but the state chose from the opening statement that the April 30th jail call from Austin Rockwood was the triggering event in this case. It wasn't any animosity on April 26th.
Agree with that, but I've listened to the call, and I'll say one impression I have of the call is, having listened to it several times, is your client is kind of, here's this story about Rockwood's girlfriend having been hit with a bottle by Harrison, and is very quick to say, I'm gonna kill the guy, or something like that. I don't remember what the exact words are, and you almost wonder, maybe was there something else, some other animosity in the background that preceded that, and in which case the video would be helpful, wouldn't it?
And that's what we shouldn't allow, relevant evidence, especially 5403 evidence. You should not be overcoming that because you're speculating that, well, maybe on the 26th, he has some animosity. The state had the opportunity, and they have the burden of proof here. They chose not to put on any evidence that showed on April 26th, April 27th, April 28th, or April 29th there was any animosity between Canady and Harrison. That's the state chose how they chose to present their case. What they chose to present their case was on April 30th, the telephone call from Rockwood set in motion of events where Canady and Evans went and confronted Harrison at the bar in Sioux City. It was at that time was the triggering event. So anything that occurred prior to that, we could speculate. We're speculating on, did he say teso? Did that mean that he had animosity? This court cannot become a rubber stamp for abuse of discretion, one way or another. We cannot just say, you give the court unfettered discretion to admit any evidence that they think may have some relevancy to the case. We have 5403 for a reason. It's the safety net here to prevent certain evidence from not to be admitted. In this case, this evidence should not have been admitted. It was you.
this analysis with similar types of evidence. We've said we're unlikely to find prejudice if the evidence admitted kind of pales in gravity or comparison to the actual crime that's being tried here. So if that's kind of your framework and you're looking at it, you have a video, and correct me if I'm wrong, it's Canady and Evans in the rap video together, right? Yeah. Which would show they know each other. They have some sort of close relationship, which could be relevant. It doesn't matter. I mean, the state's entitled to prove its case. It shows they have a relationship, that it's more likely that they would aid and abet each other. But the crime here is a shooting. So if you compare the evidence that was admitted, which is 20 to 30 seconds of a song clip, where's the prejudice or the risk that the jury would reach a verdict out of prejudice and passion when you have a shooting captured on videotape that's being narrated by an eyewitness?
Idea of what rap signifies to jurors. And if you look at the research studies, it shows clearly once jurors are told rap, something was introduced with rap, a defendant doesn't get a fair trial because they have a negative connotation when it comes to the idea of the rap genre. And the research is undisputed.
About that question. So are you suggesting that in this case today that we should rule that there's a categorical rule that evidence of rap cannot be entered against the defendant even when it's their statements rapping over a song? Is that what you're asking for? And would that essentially...
This case, exhibit number 90 should not have been admitted into evidence because of the rap, element to it and the negative effect it had on the jury were misled, confused, and also, you know, the prejudice from that video. So we're only asking based on the facts and circumstances of this case. However this court wants to rule, whether it wants to reserve another day, whether we have a per se rule with respect to rap videos, we're not asking the court to make a blatant ruling here today. We're only asking for with respect to exhibit number 90.
Going back to Justice McDonald's question, usually our big concerns about 403 issues, especially if we're going to reverse on that basis, would be if we thought there was sort of an independent basis that the defendant was convicted that is not the crime that they were charged for, something else, something horrible that they did or said or whatever. This doesn't seem like the kind of situation where we'd be afraid that, oh yeah, they found this conviction based on the rap video and they weren't really paying attention to the overwhelming evidence that your defendant was involved in a killing.
First of all, it's not overwhelming evidence that he in the case because actually the jury found for a lesser included offense. So one can safe assume and safe to clarify that or classify this case, there was not overwhelming evidence on the murder charge and which was the killing because the jury actually returned a very favorable verdict to Mr. Canady by finding a lesser included. We don't know what the jury was holding on to in the jury deliberations, whether they were holding on to this video, whether it was a Snapchat message. The reason why he was found guilty instead of not guilty on all the charges. And we don't know.
If you were to go your way on the rap video, why isn't it harmless error?
Because, as I just said, there was not overwhelming evidence in this case. If you look, the jury clearly had to come to grasp here and made it, and there was an extensive deliberation with respect to what ultimately a verdict they rendered. Because in this case, they did not find him guilty as charged. There was some deliberation. There had to be some thought in this case of why they chose to do a lesser included offense, at least on the murder charge. Whether it was a compromise, whether somebody was holding out and they were trying to get a compromise, we don't know. And I think that's the reason why it's not harmless error because the record does not show the opposite here, that his rights were not substantially affected because there's not overwhelming evidence with respect to that.
Or charges?
The problem here is we have a general verdict. Not one piece of evidence was, say, the rap video or the Snapchat message was not instructed to the jury that you only consider that under the murder charge, or you're only considering that under the willful injury charge, or you're only considering that under the assault charge. This evidence came in, and we had no clue how the jury used this evidence or how the jury took this evidence. And that's why this court has to be the safekeeper here, the gatekeeper here on this type of evidence to make sure that we are not allowing.
Go ahead, I'm sorry.
To the harmless error, though, do we need to look at that by the different charges?
No. Because the spillover prejudice, when that evidence is allowed to come in, and in the sense that the prejudice spills over to all the charges.
Right, so if we were to agree with you that it was more prejudice and it should never have come in, we still apply a harmless error analysis, though. And so wouldn't we apply that to each one of the charges? I mean, are you saying that there's not overwhelming evidence with respect to the assault charge?
Wait, what I'm saying is that when you look at the state in their case, they cited the State v. Martin. What they're saying under State v. Martin is that once you overturn on one charge, then even if there's strong evidence on two other charges, you're not supposed to grant a retrial. But State v. Martin did not have 3 charges before. This court did not. It was only 1 charge. It was the one indictable on a possession charge. There was 2 simple misdemeanor charges also in that case.
Saying that there was overwhelming evidence on the assault charge. Are you, I mean, seriously, okay. Right. I mean, there's a video of him.
Yeah, there's video.
Okay.
He was assaulting, you know.
The assault is the serious assault, but then on the willful injury and the voluntary manslaughter, those are the ones that you're claiming.
Deals with the aiding and abetting and whether or not it was aiding and abetting with respect to.
I'm sorry, Justice Mansfield.
Well, yes, on the merger aspect, with respect to the merger, I think I know when I briefed this in, with respect to in Court of Appeals, when we were talking about it, it's the idea whether or not it was a break-in action or it was one continuous action here. And what we're arguing is that the willful injury and the voluntary manslaughter is one continuous set of facts here. There's one continuous set of, there was no break. It was, you know, I think if don't hold me to this, but I think when I calculated this for the Court of Appeals argument, I think I calculated it was 5 seconds when Mr. Canady was on top of Mr. Harrison until the first shot that was fired, if I'm not mistaken. I could be wrong on that, but I believe that's what my calculation was. So this was a very quick, the willful injury and the voluntary manslaughter actions were very quick together. And I think that shows that these should merge together because of the fact that the key component here is just aiding and abetting, which goes to both.
Just so I understand this, you're not contesting necessarily that Soretti might resolve this. You're not contesting that the elements are different, but this is kind of, I don't want to put words in your mouth, but almost like a unit of prosecution or Heemstra.
I think I cited Velez. I think that's who I cited. I think that's what I cited, yeah.
An action, so these had to be charged or at least sentenced as one crime.
Yes.
Okay.
I cited State v. Velez in my argument for the Court of Appeals. Okay, thank you.
Thank you, Madam Chief Justice. May it please the court, counsel? So my understanding of unit of prosecution is that if there's non-mutuality of the elements, then you don't consider the unit of prosecution question. It's the same act violates both of the statutes, and with non-mutuality of the elements, conviction on both violations is proper. I'd also say that under Walker, the evidence here, I mean, you've got multiple shots. It would support multiple acts of multiple acts, each one constituting voluntary manslaughter and another constituting willful injury, if that were required, which I don't think it is. I want to return to what I was saying about a background motive and a precipitating motive, because you're right, Madam Chief Justice, that the precipitating motive here is the phone call where he learns the information about the girl being hit with the beer bottle. But Justice Mansfield, as you pointed out, on that call, he takes that and runs with it. And this is the kind of now, if you had told me that about somebody who I'm friends with, I would probably, and the jury could find that the natural reaction would be to interrogate that a little bit more and be like, did that really happen? Maybe there's an explanation. The existence of background animosity makes it more likely that the intent, that reaction is part of the beginning of forming a.
Today, was that argued at district court?
I think that that was the whole theory of relevance, is that it shows the existence of some animosity that precedes the phone call. That's the entire theory. And it's correct to say that the state was saying the real impetus for this event was the phone call and learning the information in the phone call. But then, that came on top of some existing level of animosity. Now, I want to point out that what the district court knew when it admitted the evidence does not include the fact that this is a Chicago group and that the song contained the name that sounds a lot like Tezo, that is, and that instead of inserting the name Tezo, that Mr. Canady was arguably just singing along. The district court didn't have that, and its ruling reflected that. It said the specific thing that makes me think that this is relevant, and relevant in a way that outweighs the potential for prejudice here, is that it mentions the decedent by name. And this is, I think, Justice Mansfield, again, you're right to point out that it matters what the theory of relevance is when you're talking about whether it's okay to admit rap lyrics or a rap video. If the theory is identity, or that these people must have participated as proven by the rap video, it's correct to say that you're looking for some sort of close factual similarity in what's described, or some level of non-public knowledge displayed. But if what you're talking about is motive or intent, that is something that's ordinarily not really provable by direct evidence and subject to inference.
That bit, why not just clip that bit of that video? I mean, instead you have him singing gang, 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 and showing money and sort of all of these other problems with it. Why didn't the state just limit it, I suppose, to that little piece?
So I think the rest of and it was limited to a significant degree, but to limit it even more, I think at least some of it is arguably relevant to show the context in which that is being said, like to imbue the mention with the sort of animosity that would be probative.
That context, you have added a whole bunch of unfair prejudice, haven't you? I mean, does that balance? Does that come close to balancing?
There were an objection that it should have been more heavily redacted, then that would be something to consider. And I think that the other problem is that the district court heard what it thought was a second reference to Tez later in the video after the first one. And I took my best guess at what that was in the application for further review with a footnote. The Court of Appeals disagreed, but they said even if we assume that's true, it doesn't change our analysis. Now, I think that when you start looking at harmless error and prejudicial value, it's really important to remember the verdict that we actually got here. I mean, Mr. Bender just said it was a very favorable verdict for Mr. Canady, given the facts, that this jury considered whether the evidence proved these charges and found it proved some of them and not others. I think that this is the kind of situation, and especially, Justice McDonald, you're right to point out the analysis from White, that potentially prejudicial material has less of an impact on jury decision-making when it's drowned out by severely more evocative facts of the underlying offense itself, such as a murder caught on video and narrated by the victim's fiance, who is herself describing the assault on her. And so in this case, I think that it is correct to pay attention to this issue and to warn that this admission of this kind of evidence isn't something to be done lightly, and to be aware of the potential for unfair prejudice. We still give a great deal of latitude and leeway to trial courts that need to make this determination without the benefit of hindsight. And that latitude, I don't think, is reflected in the Court of Appeals opinion. And I don't think that it can be said given what the district court knew when it made this ruling. I don't think it can be said that it's an abuse of discretion. Thank you.
It is hereby submitted, and court is adjourned for the afternoon.